Young penny for baby say, if you are seeing her, will be ma to be check. Why not HL? So we'll pay IT, won't be 1 year, so we'll pay support. Slam Technology say your #1 partner. Your office will US in here, your office will Ghana, so ye, your numbers ni kuhono. So we should share IT classes, we share career coaching, we share support for business, cybersecurity. Free, na your partner. Yaba fear wow. Slam Technologies, transformation with excellence. Free is ya baby biarao me
Living in Ghana, abroad, a first-timer visiting Ghana, or a company wondering where to get quality service providers in Ghana for any job, then Ejumapa On Demand Services is here to assist you. Ejumapa On Demand Services connect requesters and service providers such as masons, plumbers, electricians, auto repairers, home and office cleaners, trash collectors, rent agents, spa attendants, roofers, beauticians, teachers, CCTV installers, and all artisans on one platform. Yes, one platform. Trust Ejumapa On Demand Services to sort you out any day, anywhere, and at any time. To download the app, please visit the App Store and Play Store or visit our website www.ejumapa.com.
More about SVTV Africa. So thank God it's Friday. We shall be live on SVTV Africa. If I'm DJ Nyame, you streaming live our YouTube channel SVTV Africa. So also neighbor streaming live. So him in Facebook account. You call Facebook at check. And then send me the TikTok account. So see I streaming live. So our Facebook SVTV Africa. So many wanna thank God it's Friday home 5:30 GMT. I'm in lawyer wisdom akao wise man solicitors every Fridays. Be I'm in no I say you do UK in come into so UK and now planning so be UK and now say any information about UK. I'm in lawyer wisdom akao every Fridays. Be I'm in no I say. And see me wasting much time in a lawyer ever be doing common and then they see UK for there. They be only be bomo. Into share link in my own be no one joining our question be up so be sana. Comment section or type or the type of question up so be sana. Time a minute do the better screen so now not as a obekin mamo. Aha into comment section in the modia question up so be lawyer ask lawyer obet maybe sana na obey you no na ene lawyer said then share caption na. My uncle stress that lawyer wisdom akaho chairman akwa baboko there.
Yeah,
Combination. Bibia boko lawyer wisdom akaho straight and then what about studio then? What studio A? Back to studio A. Lawyer check sound and I'm saying shut down until kamuti lawyer and lawyer there oba beginning na. I said nothing we engine warming a bomb somebody to SS pack no.
What's it you
see I'm telling you oh warm me up ba oh warm me. Lawyer wisdom account. And now about the anchor straight, also then echo updates, then echo information, then echo so UK. And I also then yen so Eddie Vivi by ya bisa na ewuno. Also then e betimi aye. New in bi aba na format bi wo ho na format bi ani ho. Lawyer enti over to you by the enti. But lawyer sound what lawyer anka lawyer oba bigi lawyer check o mic no. I say it's a breaky big cry check o sound no.
Oh, I think me
But see but by Oma I say I feel sparking. But lawyer I say auto mic. I say auto mic can kasa podcast mic can kasa show laptop no. And no
me Michael, but yeah, now I feel say we're stronger and better. But
see I per mic mano. It's lawyer. What by enko my update rundown bibi a opese ehun ekoso UK. Over to you.
Me children, you just say me just say ye hu ye. I don't want to ya sign a share biom. And then me person me kasa fa options ewo ho yen ayaba na ye VV to send near DJ Bosono, ye visit visas, and I ye visa ye wanna expire. I want to look at the options ye want. Say yeah, but based on popular requests now, say I want to go over it again as to options are obi a wo krom ha and obi a wo de visa pa ye woni asitina wo visa ne wo upese utna krom ha in accordance with the rules ye pese hwe kwan a ebetime afaso. But before that, remember one or two things so and also you can't over and over that, but it's still going on. And remember so then I go to the main topic for maybe some minutes. Now questions be over. My questions ni honsua. Then that will be it for the weekend. So number one, yakasa over and over and over about documents, genuine documents, false documents, genuine documents, false documents. Yakasa about it so many times, but you'll be surprised that a bit that so you see documents Omudrin say home office for and entry clearance officers will not see it that is a fake document. So say no, because of technology, the way I want to check documents to show say a genuine document or not has changed. And your first time now, over for paper, no more share address day. Because say more sophisticated machines are only check whether information now whether it is genuine, even the font size. Sometimes the font wallpaper, they are able to determine whether it is Arial 12 or it is New Times Roman or it is whatever it is, different fonts. And to obey to me share and now almost to share magnifying glass. I'll see no one who said the font sizes are totally different, and the kind of wording it is, and now whatever it is just not right. Now, there was a situation obi egi letter efi a secondary school edibaye. Now, Usha Brofona headmaster no is supposed to have written straight away. Who elementary school scholar and say this cannot be a headmaster's English based on a no application. Now, the entry clearance officers, excuse me to say, they don't just accept everything that you present. They just have to scrutinize it and be sure that the documents you're presenting are genuine. And they refuse the application and point out to the fact that the documents now will be provided from the secondary school is just not genuine because we share the grammar. The headmaster is supposed to have written clearly does not indicate that this is the English of a head teacher. That is one. Two, there was no reference number on the letter. That is also an indication that it cannot emanate from the school because every school has a letterhead and the letterhead will have sections for reference. Now, ultra letter be about a particular child. There has to be a reference with regards to that child's application or letter. There was no reference. There was the grammar was just bad. There was no reference. The letterhead does not clearly show that it is from that school. And based on they concluded that documents now the year application was a false document. And as a matter of fact, sometimes you question a few into a few questions. We ask some very probing questions. Now the answer now with the mind clearly shows to you that no, near home office for Ekano because on checks someone who said the documents are provided a fake documents. And we keep saying this. I don't see why we should keep doing this. The days and the years, 10 years, 20 years, 30 years ago, when people could just do anything and get away with it, those years are gone. And yet, and at this day and age, you can't just present anything and expect that the Home Office will just accept it and you just walk in the park and go away. No. And say, please ensure that the documents are genuine. Now, OJ letter every school, and OJ letter every hospital, doctor, now, you can also go through the letter. In fact, teachers, doctors, pastors, we all make mistakes. And it's all kind true. Now there is an error in it. You can politely point it out to them that, oh, I am a way, no, it should have been so or that the other way around. And they can correct it for you, particularly when it comes to the spelling of the names. No, yeah, we pay attention to that. So the point I'm driving at is every document you use to support your application should be a genuine document. It should not be a fake document, because if they find out that it is not genuine, it's a false document or fake document, and no, can affect your application, and subsequent applications I'll be here in future, can also be affected. So my advice is, let's all try to do the right thing by providing the genuine documents to support our applications. So please take note of that. Some time ago, so Mikasa about the old birth certificate of a child and the new birth certificate of the child. Say, who the old one, no, any new one, no, Eddie Eba, make sure that the reference numbers, the serial numbers on the old one is what reflects on the new one, because we share new birth certificate now, issue now. It's a certified true copy of the old one. So if it is a photocopy, what is on the old one, or if it is a mirror image, what is on the old one has to reflect on the new one. So you cannot have an old birth certificate. The serial number is different from a new one, the serial number on the new one. And so the old one, no, and a new one on the application, please ensure that the serial numbers are the same so that it doesn't create any problems for you. So it's not concluded that the application or the document is fake. That is also one side we have to pay attention to. Please, let's take note of that. Otherwise, we find ourselves in very difficult situations that we cannot solve. So take note of that. The other issue I want to raise is this. So the serial number now, old one so, and then the what new one so, and yet the same. Then there is no point set within me and any application, because that is going to raise a problem. But you could, of course, explain why you are using only one, particularly the new one. You can't use the old one because they are not going to accept the old one only. But who using new one and near would the friendly passport and I want a passport nimpo. Not would the evidence account ebia ayoba would the DNA account that confirms why, or that confirms the relationship. Ebia na old birth certificate no ujie, but because of movement from one place to another, maybe you move from Konongo to Suyang or from Suyang to Accra, and in that process of movement, you've lost your birth certificate or you've lost the child's birth certificate. If that is the case, then sa uba ena uya application ediamana uba tumye DNA. Now there can new birth certificate neho. Now I explain it, say, na uwa old birth certificate now, but because of atutu 20 uyirano, and not in our the certified true copy. However, the DNA confirms say abufrano eye uba. So there shouldn't be any doubt as to the relationship between you and the child. Very important. So in that case, you use the new birth certificate and the DNA. However, so old birth certificates now and the new one, the serial numbers are the same, that you can use the birth certificates without a DNA. So please, let's take notes of that information. Thank you very much. The other thing I'm a person about so yeah, UK ha yeah applications no well we application ama uyiri se omra ana ukunu se omra. Now ubano, the first time na ubano na waware Wabadu hano relationship now break it down until you are divorced. Now, sir, one Ghana and Koye divorce now. It means you need somebody to represent you in the divorce procedures, in the petition, through to the end. Because when to me and Konon, you would need an attorney, somebody to represent you, an attorney to act on your behalf. Now, sir, what the divorce certificate ebreme? Sir, Uba first time no worry. What we do have relationship now break it down. And what call the year divorce or Ghana. So all the side divorce no ebreme. Measure so I say. The first question maybe is, were you in Ghana for the divorce? Usi Davy. Hina na representative, Usi my uncle, and also then you need to have an attorney. You need to have given the person a power of attorney, and with that power of attorney, and no, and or the ejna ho at the year divorce no emao. And to say share divorce certificate in this one. As I said, I can say, Akosia menu pay her lawful attorney, Mr. Kojo Dankwa. And Akosia Meno, or no, and a guaware, but only hunty Kojo Dankwa and a representative. And Akosia Meno, pay her lawful attorney, Kojo Dankwa. And then Yao answer, pay his lawful attorney, Joseph Kwanzaa. So clearly it shows that you were not in Ghana, but you were represented by a family or by your attorney. Let me just say your attorney in conducting the divorce proceedings. Sir, one called Ghana, who the certificate niba, and there is no indication that you were represented, that can be challenged by the Home Office. They can raise questions about the genuineness of the certificate. So I would advise, sir, so one kasa went to me and called Ghana, and you were in Ghana for the divorce proceedings. It means you instructed somebody to act on your behalf as an attorney. Please ensure that sa attorney no the ding so ever back the divorce certificate no so that they acted on your behalf. Very, very important. Otherwise, it can be challenged, and that can also be a problem for you. The other thing is this, sir, uyiri ana ukuna kojao or say marriage certificate, divorce certificate no on copy amount. Meanwhile, was you've not been served. More copy bia, more letter bia, documents bia from anywhere in the world that you are going through a divorce proceedings, or your partner is divorcing you. Now, what can't you say what divorce you are? Sir, will insist on fact copy of the divorce certificate and mawa, you can challenge that divorce, because there is no way our divorce you be one require only baby and who on the telephone number, who on address, who on the email. The person has not been served. My divorce copy of the divorce certificate no so or see on farm. In that case, or yeah, very difficult for you to also move on with your life. Because one year divorce certificate na want to make unso ungonko ware obi fufro, and as a unso ko divorce certificate fufro, just in case odi ne onu di aye onu aye no di call home officer e be kire se unso akoye fufro nti divorce onu ne dey different, unso dey different, the dates of divorce are different, place of the divorce is also different. That can create problem for you all. And say Obano and Obama say on my copy of the divorce certificate, I think you can challenge the validity or the genuineness of that divorce. Then that should be the end of it. But if they are insisting on not giving you a copy of the divorce certificate, then you have every right to challenge them in court that that divorce is not a genuine divorce. So I think we should talk things over and get it peacefully resolved so that it doesn't create problems for any of the parties. One more thing I want to update us on before I go to the topic of the day. Sec. Ubai as a student. And now you came as a care worker, a healthcare worker, a dependent, or the main applicant, or anything, any category, Ubai. Ubedu han ebia went to me uncle school no. And sponsorship license has been cancelled or revoked, and your COS has been cancelled. Wasit nano is been compressed or is been curtailed up to maybe 2 months. Now, upese uye application for from. Me who said a binimo applications be emma and bi. Pachoyenti ho ye. A binomo applications be emma nkurɔfoɔ bi a stranded. Some applications no EU applications. EU applications. Sɛ almost say my application amount yɛbɛma 6 months. Yɛbɛma certificate of application. That certificate of application no wobɛtumi ade ayɛ adwuma na nea ɛsɛ sɛ ɔmo no in terms of documentations or whatever it is. Now, the application I got to my mom. I just want to caution all of us that those applications are coming out with very bad outcomes, very bad results. The Home Office, who say trend way course, be by a student, on school no. Na obia koya application amane say o me the application betum say uye you name a grandchild. You need eba. Now, the problem, and is you will end up spending a lot of resources in that case or on those applications. Meanwhile, it will come out with nothing for you. Either the Home Office will reject the application as invalid and out of time, out of 3 months, because papa and our mame krom ha you need ampa na se ubedu krom ha. As soon as you arrive within 3 months, you have to make your application. You don't have to wait until after 1 year and sana usi ukakoye application to be here as a family member of an EU national. Home Office back say you are out of time. Way out of time. So let's take note of that. Don't waste your resources on people who are just misleading other people into making all sorts of EU grandparent and parent applications. I want us to all be alert so that nobody misleads you into making that application. Now, over UK as a student or as a skilled worker, as a health worker, as a dependent of a health worker, the application form etum, you completed an application form. Papa ding ebasa application form neso. Mama den so ebasa application form neso. One can baby say you have a grandfather here who is an EU national, or you have a grandmother here in the UK who is an EU national. One can baby say additional information section. One can nowhere on your application form now can you say you have a grandfather here. Or EU national. Ebani sign wabedu hewie no. Was sitting on the wood and obi culture will say obey application amount as a family member of an EU national. And now when we your degree, you instead of you to go on the postgraduate route or so EU applications, now what switch and also once and also no, you can't come back to your graduate visa route anymore because the requirements under the graduate visa route, you should be on the student visa before you can move to the graduate visa route. You can't go to another route and then come back onto the graduate visa route. So please take note. Ban is saying, ban usi papa ni ding ewo form niso, mame ni ding ewo form niso. Ban is saying, wabedu krom hewe ansa na grandfather of Italy, Germany, Portugal, Spain, France, and Zanaudi no application. That cannot be right. That cannot be right. And unfortunately, these applications, Emma Nkrofono, Emma Amamfono, Emma stranded students and people who have no options right now, or people who have options but haven't explored it well enough and decide to go through the EU route. What they are doing is they don't take their time to scrutinize the documentations properly before they submit the applications. How can you explain to me, sir, what the 25 years? Papa, Eddie, let's say 45 years. And our grandfather, nipa na oya application ma ose or funny so application. Our grandfather, Eddie, 55 years. So at what age did your grandfather give birth to your father before your father gave birth to you? Do the calculation, see the age gap, say the age difference. Me who be a papa no, any grandparents no, papa no, any only papa no, the age gap was 5 years. How can that be? Sir, who papa, any grandfather, the age difference between who papa, any grandfather, 5 years or 9 years or 10 years. It can't be. It means that ni omo ye ama amam for no, amoji omo resources no. Is fake. So I just want us to all be fully aware of this. Almost every week, you hope this thing. Almost every week. Now, say home office for no more say, oh, my application be home office for some here information be the call home refuse see and yeah, sure, EU application see. Your grandfather is not here. Now, these are a few questions you should ask yourself. Say, obey application amount based on the fact that you are a family member of an EU national. Ask yourself some few questions. Just be honest to yourself and ask yourself these questions. One, your grandfather now almost wahano, and your grandmother now almost wahano. Only know a contact, only know a communication. One, two, your grandfather and your friend is saying. 3, your grandfather an address DNA. Next question. Yes, say one your grandfather no munya DNA. Uber to me aye. Nipa na wo no dan ebede na woni na ye DNA. Apart say yes, mumra for interviewer. Where are you getting this grandfather to go to interview with you? Yes, if our grandfather and the birth certificate and our papa birth certificate, ebra, original, not copy, original niba. So if you can ask yourself these honest questions, if you can honestly ask yourself these questions objectively, not subjectively, not because you pass it plenty, you don't want to ask yourself questions, or you don't want to ask Nipana or Bisa when you no questions. Now would be Biakomano. Not wakako creative what should not be created. The home office because is either your application is invalid or you have made a false application or you've made an application with false documents. Now, Akoda will record so in the home office, and that can go a very long way in affecting your credibility in future. So my advice is this. So what Krumha, Ubaya as a student, Ubaya as a care worker, Ubaya as a dependent of a care worker, where you will course no, you should go on to the graduate route. And now you are on the graduate route, and you want an option to stay. Obiaka shows said, you bet me a you dianamawa. Ask yourself some questions. Maybe no, people padding a application form no, any day. Near yes, say for my grandfather, no, your friend is saying, Menena Shada, minimum address, minimum the telephone number, me only EU settlement scheme reference number. Yes, even quite DNA. Or so and I'm minimum. These are questions you should ask yourself before you commit any resources to anybody to make an application for you. One yes, sir. Would the Nyama never call? Sometimes who crown own name who she home office Eddie Nyama bar refuse our bars. I will say, not just said Nyama Bianca wouldn't move no, and the Jaco fra documents be not a creative problem for you. So please take note of this. Your father's name, your mother's name, no indication that you have a grandparent here. If they call you for interview, your age, the age difference between your grandfather's age and your grandmother's age, and yourself and your father and your mother, who is the family member of an EU national before you. These are questions you have to ask yourself before you commit to anything. Yes, think of our grandfather and the passport, original one, yes, if on the birth certificate, ask yourself these questions and don't be desperate in getting into situations where you will not be able to resolve them after some time. So these are issues that are rising, matters are rising. And so I want to look at this before I quickly spend about 15 minutes, 10, 15 minutes on the topic for the day. I hope this will help somebody so that you don't waste your limited resources on people who are in the system and just taking advantage of others who need options to regularize their stay. Thank you. So, and then I want to answer this question. After your visa has expired, how to become legal in the UK? And after your visa has died, visa is died, your visa is expired. Legally. Of course, we've treated this topic before, but I just want to give some nuggets, bit, and then maybe we'll go into details some other time. We pick one topic and then we go into it. Number one, generally, so what about UK as a student, as a spouse, if you who are regretting or buy a relationship, now break it down. There might be options of victims of abuse that is there. You came as a spouse, you came as a student, you came as a dependent of skilled worker, etc., etc. Now we visa na be war. And now you even came with a visitor's visa. Number one, Emrani Chrese, you will be a friend of private life, appendix private life. Emrani Chrese, so what Nakrumha, we are under 18. Now, what Nakrumha for 7 years, you are able to make an application based on the fact that you've lived in the UK for 7 years, but you must be under 18. It means you came to the UK when you were maybe 9 years, 9 plus 7 is 16 years, you can make an application. Or you came to the UK whilst you were 10 years. 10 plus 7 years makes it 17 years. You can make application to stay in the UK. Or you came when you were any age plus 7, you will still be under 18. You will be able to make application to stay in the UK. That is for a child under 18. Or se uni papa ana mame edi emofra ana abofra baye, and the child is under 18. Na papa no any mame net na krum ha for 7 years with that child. In that case, obetimi application ama ubano based on the appendix, a private life for the child. Now we are parents, no so betimi application under appendix FM section LTRP based on the child. So the child will make an application and you will make your application based on the child. Or you can make the child's application and yours, and you can all get your stay. But as I said, which I said, the child is under 18 years old, and secondly, what's not room for 7 years at least. Ansana with me application. So that is for people under 18 or parents of a child under 18. Thank you. The second option is so we are between 18 to 25 years and you've lived in the UK for half of your life, half of your age. In that case, one submit my application to stay in the UK. Example, you are 18 years, half of that is 9 years. So over to me, actually say you've lived in the UK for 9 years, you can make an application to stay in the UK. So what did 20 years, you make application after 10 years because you have to prove that half of the age that you are right now, you've been in the UK for half of that. So if you are 20, half of that is 10 years. Prove that you've lived in the UK for that number of years, which is the 10 years. If you are 22, half of that is 11 years in the UK. If you're 24, half of that is 12 years. So just check your age and divide it by 2. And ask yourself, have I spent this number of years in the UK? And that is also under appendix private life between 18 to 25 ages. People who are aged between 18 to 25, that is for you. Then from 25 years and above, and also appendix private life, but you have to show that you've lived in the UK for 20 years, and that you can make an application. How do you prove 20 years? GP, bank statement, P60, pay slips, tenancy agreement, gas, water, electricity, TV licenses, etc. For 20 years, if you can provide these documents, then of course you can use that to support your application to stay here in the UK. That is for people who are 25 years and above. There is also a provision which says if you are less than 25 years in the UK, so if you are less than 20 years in the UK, you haven't lived in the UK for 20 years, now so there is an insurmountable obstacle, or there are compelling reasons why you cannot go back. There's a word for it, an insurmountable obstacle, or yes, let me just put it that way. You are able to make an application, but you have to show that you cannot go and integrate in the country into which you are going. In that case, it's less than 20, but you have to show good reasons why you cannot go back. There is only one case that I remember we did, and it had a semblance of success, even that it wasn't successful because we had to go to court. Now, Onono Obi Osini Uncle Bin from Sierra Leone when they were having some fight there. So he came, the uncle Bajano Emma Obi, a family member, a friend, and then he went and the uncle got killed in the war. And Tionono, because he came as a youngster, he has nobody to go back to in Sierra Leone. So that is an argument that they cannot go and integrate in the country where they have to, where they will be expected to go to. So that is an option. But Obisano, I would advise you, if you can, wait for 20 years and then you have your chances of you have a better chance of being successful. So that is it. The second option, so I've talked about 0 to 7 years, 0 to 7 years, 18 to 25 years, 0 to 18, 18 to 25, 25 years and above. If you are in that category, you can regularize your stay here in the UK. The other one is if you have a child. This is called child-based application. Child-based application. If you have a child and the child is a British citizen. Now, your child is a British in Ghana. How? The father is British, the child was born in Ghana. So you were looking after the child. Eventually, you got a visa to come and visit the UK and you came with your child, or you came alone. If you came alone and your visa is expired, you can let your child come and join you here. If the child is under 18 years, let the child come and join you here in the UK. Once the child is integrated into the system, the child goes to school, the child has a GP, and you are on the records as the father or the mother of this child. And you are, then, of course, even though you came alone, and your child came to join you later as a British citizen, you are able to make your application based on the fact that you are a parent of a British citizen child. That is also an option for you. Under Appendix FM section LTR PT, you can make that application as a parent. Of course, with reference to all the case laws and Article 8, etc., etc. So that is also an option. You had the children in Ghana, or you had the child in Ghana, the child is a British citizen, you came with a child, or you came alone and the child came to join you later, you are able to make application based on that child. The other child application is you give birth to the child in the UK, the child is 7 years old in the UK, you are able to make application based on that child. But you can first of all apply for indefinite leave to remain for that child, and then you do yours later, or you can do it for the child and do it for yourself as well. But if the child was born in the UK, you must as well just go for indefinite leave for the child, and then you can then apply based on the child as well. So that is for a child born in the UK that has lived in the UK for 7 years. So let's take note of that. Or the child was born in the UK, the child is a British citizen because the father or the mother is British. The other parent has nothing. As long as your child is a British citizen, you are able to make application if there is a genuine and subsistent relationship between you and your child. You can do that as well, and on that basis, you can get your stay. Usually, you'll be given 2.5 years limited leave to remain. And after that, you keep renewing it until you get your indefinite leave to remain in the UK. So take note of that. So you have your own child, your name is on your child's birth certificate. You are involved in the child's upbringing, welfare, and well-being. Your name is in the school, GP, etc., etc. health visitors know you, they can provide letters and stuff for you, you are able to make an application based on that child. And of course, you will be able to get your stay in this country based on your child. The other child application is if you have an adopted child. So assuming you are married to a lady or married to a man and the man is settled, but they have no child, and that person is able to adopt in the UK, and the adopted child is a British citizen, because your spouse is married to an adopted child, and because your spouse has adopted a child, not married to, but your spouse has adopted a child and the child is a British citizen, you have become the parent of that adopted child as well. Or if you can show that you've lived together with the adoptee, the adopter, actually, the adoptive parent for 2 years, you are able to make an application also based on the fact that you are a parent of a child that is a British citizen, an adopted child that is a British citizen. So that is also an option. Let me say that again. Mr. A is a British citizen. He has adopted a child, and the child is a British citizen. Madam B is married to Mr. A, and Mr. A has an adopted child who is a British citizen. Madam B has become the stepmother to the child that is a British citizen. Madam B can make her application based on her spouse and the adopted child. She should be able to get her leave. In fact, that even creates a very strong bond between them, or very strong argument that, look, this child has been without parents for all these years, and now he's found a home. We want to create a comfortable home for this child. In other words, so that this child can grow up in a proper family home. So that can be a very good line of argument in support of your application. So a British child, 7-year child, adopted child. The other one is child-based also, but of course based on the partner. If you have overstayed your visa, and you enter into a relationship which has to be genuine and subsistent, and you are blessed to have a stepchild in that relationship, then you can also again make application based on your spouse and your stepchild that is a British citizen, or that is at least 7 years old. In that case, you can get your leave to be here as well. You can get your leave to be here as well in the UK. So you don't have a child, but your wife has a child. You have become the stepfather to that child. On that basis, you are able to get your stay here. Now, there is nothing like me buano, me kofani benefit school. Me supporting no. And me person me fa abofrane so. There's nothing like a stepchild or step parent application. There is nothing like a step parent application, as far as I know. What application people refer to as step parent, they say, want to me emfa abofrane pet so any application. As long as when my amenity the same address, no, they will not give it to you based on the parent, they'll give it to you based on your partner. But people make mistakes. So a step parent application, there is nothing like a step parent application. It has to be a partner or a parent application. Please don't let anybody deceive you. Oh, mameno, oh, they be once or but wait me a funny banners, mamini dear. Only mamini, it won't work. When to make of be back any application based on abofrano. While once you have no relationship with the father or the child's mother, you have no relation with them. It doesn't work that way. When to make of application based on you, it does not work that way. So I've heard people tell me step parent application. What it means probably is that you are married to a partner who has a child, and you have become a step parent to that child. But the application is based on your spouse and on your stepchild. You cannot take the child's father out, and you cannot take the child's mother out. You have to. It's a family unit. So please take note of that. Obviously, if it's a stepchild, your name will not be on the birth certificate. So that shouldn't be a worry ground. But if it's your own child, then your name must be on the birth certificate to support your application. And of course, it's not just having your name on the child's birth certificate. You must have proof that there is a genuine and continuing relationship between you and the child. Pictures, etc., documents to support that you are actively participating in the child's life. Not that you've given birth, you have nothing to do with the child, and then you go make application based on the child that you have nothing to do with. It won't work. You need evidence to prove that you are involved in the child's life. Another, if you overstay, another way you can stay in this country is on medical grounds. On medical grounds, I think I take this, then I take some questions, see if there are any. On medical grounds, it means if there are serious medical conditions, you are going through serious medical conditions, serious medical conditions, and you have the proof that your condition is dire, serious, compelling, compassionate, and you can prove that, then you can make an application based on your medical condition. Now, of course, it doesn't mean that you have a headache every now and then, you have migraine, and therefore you're going to make application. The Home Office will not even mind you. Or you have a knee pain, your knee is aching you, or you have arthritis, and therefore you're making application based on that. The Home Office will not pay mind to you. When we talk about serious medical condition, we are looking at very serious ailments. You can just name them. Sometimes you can name them, the cancers and all kinds of things. Sometimes mental health conditions, etc., etc. You could base that on that application. You could base an application on those things, and then you can make an application to the Home Office. But you have to prove that there is a medical evidence to that effect. So if you are having medical conditions, you need a report from your consultant. You need a report from your consultant. The consultant must give you detailed reports as to the diagnosis, the prognosis, how long you're going to be on the medication for. Is there the possibility that if you leave the country, you can get medication? And even if the medication is in that country, are you able to afford it? Because sometimes the medication may be available, but you can't afford it because you don't have the money or even the strength to work to buy those medications. So these are arguments that you can make to support your application, but you need a consultant's letter or consultant's report based on which you can then make your application to stay in the UK if it is on medical grounds. So DJ, I'll leave it there. I've got a few more. I've got domestic abuse, modern slavery, and EU applications to say, but let me just leave it here, and then maybe I'll take some questions if we have any at all for this evening. Thank you, DJ. Hello, Kojo BY. Good evening. Good evening. I hope you're doing good. I am here in the UK with my wife as my dependent on postgraduate work visa. We have barely 1 year for our visa to expire, and we've tried several ways to switch visa. Any advice? Well, this is a tough one because you are married. You are a married person, and therefore the advice I'm giving about being a stepfather, being a father, etc., would not apply to you because you are still married. So if that is the case, then I hope and pray that you find something sooner rather than later, particularly with the health and care. But if you are going into that sector for sponsorship license, make sure you are not on the code, which is 6135, 6136, 6145, and 6146. If you are on any of these codes, you can't have a dependent. But if you have another code, maybe 6144 or 61 something else, then you'll be able to have a dependent. Please try and get the sponsorship. It can be any skilled worker, construction, IT, accounting, healthcare, without those codes, or any other section. Otherwise, you may end up being an overstayer, and that will make life difficult for you. I can understand your difficulty, but unfortunately, you don't happen to fall within any of this. But if you wish to discuss this further, can you please give us a call on 0208 0165 384, 0208 0165 384. 0208 0165 384. 0208 0165 384. And then you come in, we sit down, you ask me questions, I ask you questions, I give you answers, response. We explore, we explore, we explore, we explore. That is what I can say. Come, let's explore. FJ Anochi, hi, good evening to you too. Will the new guidelines about English language test requirements change from B1 to B2 for the leave to remain affect people already on the 5-year route, or will begin with new? Well, usually if there are changes in the rules, it starts from when the changes take effect, or when the change takes effect. So those who are already on the 5-year route as a spouse or so, if you were on the B1 route, it should still be B1. I don't see why the changes should affect you. So right now, I strongly believe that even if there are any changes, it will still be B1 for you, but maybe subsequent from when the laws change, then it may go to whatever level it is. We don't know if it's going to be B2, but we hope that it wouldn't be too high to affect people. Thank you. Richard Sego, you have to work 3 months before you get COS, and you have 60 days to. You're right. I know. You have 60 days to look for COS after cancellation. What would one do if he gets a job and have to wait 3 months, but the 60 days is near? I understand you perfectly. I know exactly what you're talking about, because the 60 days will expire before the 3 months is up. It means you have become an overstayer. However, there are options that we can explore. Again, I think I'm better off this. We are better discussing this if we you come, we sit down, we explore what options are available. How soon do you anticipate getting the COS, etc., etc. I'm sure there might be some conditions you are going through. Just as an example, was somebody I know of, as an example, somebody I know of had a 60 days, and she was already working in a company. She had done, she had to do the 3 months, but before the 60 days is before the 3 months is up, her 60 days would have been out. But she has a medical condition. I hope you are listening to me very carefully. She had a medical condition, so she put in an application to the Home Office based on her medical condition. And because she made the application whilst her 60 days was still pending, she is deemed to be in the UK legally. So the 3 months was up, she still had an application in the Home Office, and then she switched to the. So come, let's explore the options that we may be available. And if I ask you questions and there's something in your life that can be used to help or assist and direct you, we will do that. Thank you very, very much. Vida Adoma, hello, Sister Vida, how are you? Sister V, how are you? Good evening. I applied for my settled status with my pre-settled, which my pre-settled will expire in November. I've been given 5 years again. All right. Yes. If you are not 5 years before you applied for the indefinite, you will be given another 5 years. However, you don't have to wait for the 5 years, the second 5 years to expire. So if, assuming you are going to be 5 years in the UK based on maybe your parents or your spouse in January next year, and you apply today, they'll give you another 5 years. But after January next year, which means the first 5 years is ending in January, you can then apply for the settled status again. Means you have now done the 5 years. The time you did the first 5 years, I'm sure the second 5 years, maybe you didn't finish the first 5 years. That's why they gave you another 5 years. Or maybe you didn't send the documents that you were required to. But once you have hit the 5 years and you have the documents, go back and make another application for your indefinite. Don't wait for the second 5 years to finish, which would be 10 years. No, don't do that. Thank you. Mr. Paul Ajima Opambo. How about if parents on skilled worker and dependents visa give birth in the UK? When should a visa application be made for the child? Well, if the parents are in the UK and they are here legally, they can choose to make an application for the child, and the child will be given what the parents have. But my point is this: if you are not traveling with the child, the money you are going to waste on that application for the child, what's the point? What's the point? The child is born in the UK anyway. You're not traveling with the child. The child is not going to work to bring money in. Why do you go and spend £2,000-3,000 for an application for that child, and then you put it down? After 2-3 years, it expires. That money is of no use. That's my view anyway. So you have to assess it. If your leave is valid, you have the option of waiting until you get your indefinite and you apply for citizenship for the child. You register citizenship. Or if your leave is valid, the child is born in the UK, you can decide not to apply for this child because the child is born in the UK anyway, so not subject to immigration control anyway. You can just wait until you get your settlement and you get the child's citizenship for the child. Otherwise, you'll be spending a few £1,000s for nothing. Well, that is my assessment of the facts. Mr. Boafo, hi, Drew Boafo. Please, what advantages does a person with a settled status enjoy over EU pre-settled status? Example, studies, visa-free traveling countries, and apprenticeship and career training opportunities. Yes, well, yes. Settled status means indefinite. You are here indefinitely, and indefinite means you can travel in, stay in Ghana for maybe 2 years or more. Stay in Ghana for up to 2 years. But if you look at the EU thing, I think I see 5 years somewhere, but I still work with 2 years anyway. You can go to Ghana, stay for a year plus, and come back. No problem. A person on pre-settled status cannot go and stay in Ghana for a year plus. That can affect their residency requirements. That is one. Studies. If you have a settled status, that is indefinite leave to remain, and you want to study, if you can prove that you've been here for 3 years and 1 day before the start of the course, and of course you have indefinite, you may be entitled to home student fee rather than a foreign student fee. So that is also an advantage for you. Now, if you want to travel to another country, because they know that you are here permanently or you are settled in the UK, they are more likely to believe that you will come back as compared to somebody who is here with limited leave to remain. So that is also an advantage. As for visa free, I'm not too sure. There are countries, as long as you're not a British citizen, you will have to get a visa to go to almost all countries, except maybe some African countries where Ghana and they don't have visa arrangement where you have to travel to those countries. But apart from that, there are other countries you have to get a visa, even though you have indefinite leave to remain. But if you have citizenship, then you have a wide range of visa-free countries you can. So apprenticeship, yes, you can get it. Career training, like you've mentioned, and a lot more. You may be able to access benefits if you are qualified for it. You can get benefits if you're on a settlement that is indefinite leave to remain, etc., etc. So yes, it comes with a whole lot of advantages, particularly when it comes to studying. You have a lot of advantage compared to someone who is on a pre-settled status here. Thank you. Mr. Ewusi, I want to ask, what are the steps one can take if you want to use your newborn child for your documents in the UK? Well, my question would then be, what is the status of the child? Is the child a British citizen? Does the child's mother have indefinite, or is British, or is an EU national that is settled? In that case, the child will be a British citizen. If the child is a British citizen, automatically, by virtue of the other parent's settlement, and you, the other parent, the man, you have nothing, of course, as long as you can show there's a genuine and subsistent relationship between you and your child, of course, you can make an application under Appendix FM, Section LTRPT of the immigration rules. You can then make an application based on that child. The child doesn't have to be 1 year, 2 years, 3 years. No, it can be 1 month, it can be 2 months, it can be 3 months, it can be 4 months. As long as the child is settled, the child is British, you are able to make an application based on that child here in the UK as well. Thank you so much, Mr. Ewusi. Good evening again. I'm here in the UK as a dependent on a postgraduate work visa. We will barely have one. Yes, I think I've answered. This was the very first question that I responded to. Good evening. I'm here as a dependent to join my dad. Okay, so I'm here as a dependent to join my dad on indefinite leave to IRL. I have done 3 biometrics, but all have been refused. The reason for my refusal was my age. When I entered the UK, I was 21 years old. Is this is I believe it is an EU application, because you mentioned 21 years. You are that on the IR. Now, if you are more than 21 years old and your family member is an EU national, or your sponsor is an EU national, you need to show the first one we call relationship, by using birth certificate, DNA, and other things to show relationship. And secondly, you show dependency. What shows that you are still dependent on your EU sponsor? Money transfer from your account from his account to your account, to show that he is supporting you. Of course, maybe you are living in the same house. Daddy is paying all the rent. Daddy is paying all the bills, gas, water, electricity, everything. He provides for food and everything. Yes, you live in the same address with him. In that case, you have proved what we call dependency. Now, if you cannot prove dependency, then they will refuse your application. In any case, there was a recent change in the rules which says that the Home Office, you only have to prove dependency at the beginning and not throughout the 5 years. That is an option. If you can explore that option to show that, yes, you have proved dependency at the beginning, and therefore you don't have to be dependent throughout the 5 years. If you can talk to us, we can get you to make that application based on the change in the rules, and then we explore that option for your indefinite leave to remain. It's ILR. Thank you. Blay Alfred, hi. Good evening to you too. I have my applications as a spouse partner still pending as 8 July 2025. Yes, it's taking time. It can take, usually it can take, if you have to meet the financial requirement and other requirements, then it should take 8 weeks. So if yours is within that category and it is up since July, then that is too long. You should write to the Home Office for an update, or you should raise a complaint. They should respond to you. If, however, it is not the type that you had to meet the financial requirements, then it can take up to 12 months or more. So if tell me which category yours falls in. It's either the 8 weeks or the 12 months. The 8 weeks is for people who have to make an application to show financial requirement of £29,000. If yours is not part of that, then it's up to 1 year for you to wait. Mr. Pampi Luminati, I have a partner who is a British child. I have a partner who has a British child. I have a partner who has a British child. How long can it take for me to get a stepfather application in after the marriage? Well, immediately, as soon as you get married, today, you can put in the application today. If you have all the other documents, bank statement, pay slips from your partner, letter from GP, letter from the school, tenancy agreements, everything to show that, bills to show that you're living together, pictures and everything, you can show all of this, then certainly you can start the application today. If you're married today, you can apply today. Maybe you already have proof that you're living together as a partner in the same address over this time. You can go ahead and make the application. You don't have to wait for 2 years. Now, if you are not married, please pay attention. If you were not married, or if you are not married, then you have to show 2 years cohabitation or 2 years living together. If you marry today, you can apply today or tomorrow. If you are not married, then you have to wait for 2 years evidence before you can apply. So please, that is the difference. What time can you start preparing for the application of citizenship after settled status, and what are the exams and requirements? The preparation starts from the day you get your indefinite leave. You have to wait for 1 year. 1 year from the date you get your indefinite before you can go for your citizenship. Example, if you get your indefinite, or if you got your indefinite on the 17th of October 2025, you have to wait until the 18th of October 2026. If you got it today, you wait until the 18th of October 2026, 1 year exactly. And then, DJ, can you take me to the other question, please? Thank you. After several, that's 1 year, and the exams is B1 and life in the UK test. B1 and life in the UK test. But the B1, you don't have to write the B1 if you have a degree. Maybe in the UK, you don't do the B1, or you have a degree from outside the UK and ECTIS, ECCTIS, that organization can confirm that yes, your degree is equivalent to a degree here in the UK. You don't have to do the B1. But the life in the UK test, you have to do it regardless. Even if you have a degree or not, you still have to do the life in the UK test, unless you are from a country that is exempt from that. Otherwise, you have to do the life in the UK test. In fact, the life in the UK, I think it covers almost everybody. You have to do it unless you have a medical exemption. Then that's it. Thank you. And general question, yes. How long does based on your your British child application take? If it is the first application, you have no visa in the UK, it can take 1 year. If you have a valid visa and you are going under the 5-year route and you meet the maintenance requirement, it can take 8 weeks. Or if you have a valid leave in the UK and you are going under the 5-year route and you pay the express or the super priority, it can take 1 day. So it can be 1 day, 8 weeks, or 1 year, depending on your circumstance. That will determine which way. Can I go up to 2 years after including attend? Can I go up? Can it go up to 2 years after including interview? Well, it is possible. In this case, if you make it on the long route, that is the 12 months, and for whatever reason, they call you for interview, and they are not sure, they have to verify some information here and there. It could take time, but 2 years is a long time. I would say a year plus, but 2 years is a very, very long time. You have to follow up if there is something like that and it's still pending for 2 years. Please chase them or raise a complaint, and I'm sure they'll respond to you. Kwame. Hi, Kwame. Good evening. I'm here as a dependent to join my dad on. I've done 3, but yes, I think I've looked at this already. I think when you send the repeat questions, DJ gets a bit confused with them. So just send it once. I've done that. Bright AJ Kumi. Is it Kumi? K-U-M-R-H. Interest. Okay. Hi, Mr. Bright. What if you are already married but you have lost you have lost touch with your wife? What if you're already married but you've lost touch with your wife? Can you apply for divorce, and how is it done? Well, if you lost touch with your other partner, it is true that people fall out, relationships fall apart, and you are not able to maintain contact. If that happens and you want to go for a divorce, please ensure that you have searched for your wife. Show evidence that you have searched for her. Go on the social media platforms, Facebook, X, Twitter, whatever it is, Venmo, everything. There are so many social media platforms that you can show that you have searched for her and you can't find her. You have to print the evidence of the search. Or you can write to your last known address. Let your lawyer write to the last known address. They will return it to you that this person is no longer in this address. You can write to your last known GP. The GP may write back to you that this lady is no longer at this GP. You can write to maybe passport office. The passport office will say, Ghana High Commission will say, no, this person has not come to make any application, or we have no record of her current address. You can write to different places to check if that person is at that address, or you can even do a decree absolute search at the registry, principal registry, to see if the person has already divorced you or not. Now, after you've done all of this, you printed all your evidence, and then you still can't find this person, you can then start the divorce proceedings based on the fact that you have done everything humanly possible to search for this individual and you can't find them. In future, if that person comes back to say they are not aware of the divorce, you have your evidence which was sent to the court, and you have copies for yourself to prove that you did search for her and you didn't find her. Maybe the telephone number you had for her, she's changed it. The email address you sent records, nothing. Maybe you sent it and it never came back, that is not undelivered because the person is still used. You have every evidence that you've searched for her, that you can go ahead with the divorce proceedings. But if you don't, they can always come back to challenge the validity of that divorce. Yes? Thank you. It's Mr. Elvis Sapon. Good evening. A person who made an EU dependent visa and was refused but still generate a share code, can you please be of help because he has overstayed? Well, if the person can still generate a share code, then at least that helps them to stay in the system. And I want to know which visa did they make, or maybe dependent, maybe as a grandparent also, as I discussed, and they was refused, but they still generate share code. It only means that the Home Office has probably not updated their system. But if you make another application, we have to be very sure which application we have to make. But your question is, can you please be of help because he has overstayed? Yes, in a situation like this, if I'm just giving an example, if the person, for instance, has a child or has a partner or is a parent, then we could explore that option or those options. We can, of course, explore. Or if they have any other condition based on which an application can be made, those options can also be explored again. So yes, it's not the end of the road. It can be explored and see which options can work. Good evening, K. Banks. I have a permit to live under the 10-year route FLRP. I did switch after my first renewal. The email they sent me didn't explain if the switch has been done. What should I do? The email they sent to you will determine, they will normally tell you as a 5-year partner or 5-year parent. The ones we do, they always write 5 years or 10 years. You should be able to go back to your email, read the first 2 paragraphs. It will tell you whether you are on the 10-year or on the 5-year route. If it is silent on that, then my question is, did you meet all the requirements? Payslips, bank statement, the level of maintenance or financial requirements, English language, of course, accommodation, everything, marriage certificate, proof of residence, check all of that. If you meet all, or if you met all of those and you've still not gotten a clear indication as to whether you switched, you can write to the Home Office and ask for clarification that this is the application you did, this is the response you got, but it doesn't state whether you are still on the 10 years or the 5 years. So please let me know, and then we can see how best we can assist you. Thank you very much. Okay, Salifu. Good evening. I'm a dependent and my main applicant has refused to cooperate with me by refusing for us to have anything in common for the past 2 years and counting. But our visa is valid until 2028. Please, what's your advice for? Well, why has the main applicant refused? There must be a reason. Now, if the reason is that the accommodation, maybe the landlord doesn't allow anybody to put their name there, then I would advise, if it is possible, why don't you work it out with your partner so that his documents can come to your address, or I mean he can come and live in your address, so everything comes through your address. In other words, he comes to live with you. If you can live with him, then he can live with you. Of course, this is an area I want to explore a little more, I know why I'm saying I need to explore it a little more. Come, let's talk. I may be able to direct you in one or two things. Otherwise, if no evidence for 2 years, by the time your visa expires, no proof of address for 2 years or 5 years, the Home Office may refuse your application because you have nothing to prove. So please, I would advise, if you can, the office number is 0208 0165 384. 0208 0165 384. You can come. If you can't come, please call any lawyer who is close to your area. Go see them, and I'm sure they will advise you as to what to do. Okay? Thank you very much. I came as a student, but I'm currently expired. But your leave is currently expired. Later, apply for EU and 6 months to stay. Can I marry someone to stay? Well, I mean, if you are marrying based on the fact that you are genuinely in love, you are genuinely in a relationship. If you are in a genuine relationship, you can stay. Let me put it that way, and let me leave it at that. But you don't go and marry only because you want to stay in the UK. So let me leave that answer there. Okay, thank you. Kweku Danso, good evening, lawyer. Good evening too. The student I came with didn't go to school. I didn't know and was sent an email through my agent that my visa was cancelled and was to leave immediately, but I'm still here. Right, Mr. Danso, if your student, your sponsor, of course, didn't attend and your visa has been cancelled and you are still here, you may be able to switch to another route if there is a change in your situation. And of course, I have mentioned a few options that a person who is here unlawfully or has overstayed can switch legally to be in the UK. I talked about 0 to 7, 18 to 25, 25 to and above. I've talked about parent route. If you're a parent of a child who is a British citizen, or you have a stepchild that is a British citizen, and you are with the partner, etc., etc. Of course, genuine relationship document to prove, you can make an application in that category. But of course, you are married to somebody. You can't marry a second person if you're still in a relationship with another person as a married partner. So please just take note of that. Mr. Danso, again, I wouldn't mind having an additional conversation with you if you do call the office so we can talk. 0208 0165 384. Or please call a lawyer who is close to you. If you are not close by, maybe you are all the way in Wales or whatever, please call a lawyer close to you. Go see them, talk to them. I'm sure they'll be able to guide you as to what to do. Or anyone. Can a person who brought a dependent for his postgraduate studies marry again after he divorced his first wife and become a dependent on the second wife who is skilled and become okay? Can a person who brought a dependent for his postgraduate studies marry again after he divorced his first wife? Okay, so the first wife is gone and become dependent on the second wife who is on a skilled worker visa. It is possible, but again, you have to know the code on which the skilled worker is. If the skilled worker, that is your sponsor, is on 6135, you can't have a dependent. She cannot have a dependent. If they are on 6136, they cannot have a dependent. If they are on 6145, they cannot have a dependent. If they are on 6146, they cannot have a dependent. So if it's any of the codes that is outside the codes I've mentioned, then yes. But if it is in that code, then no. So the answer to your question is, if you divorced, relationship is over, you form a genuine relationship with somebody here who is on a skilled worker and is outside the 4 codes I've mentioned, yes, you can apply to stay here as a
Lawyer Wisdom Akao.
sir.
Questions in there. There's a baby more. I feel say ebi more the waka Canada. I say repeated once. Ebi in some waka so me who questions in be. I think sending in an answer but one be woman. What Canada? I feel say every say repeat what Canada. Anyway, lawyer, you better say, oh, shall say no, about Bobo, nyama be so. Me no, 25 years, now you can 27 years, sir. Mean 3 months, another 20 years. I didn't feel no media, and some of qualify so many as it's now. And if you know, hey, Charlie, me met 3 months, 20 years, and some of my application. Hey, that's only 45 years. Charlie, people do. Lawyer.
45 years now. Maybe I would do 25 years now by your own. And I wait time for 20 years and to wait 45. Wait 45. No, you're more indefinite. You're more thought. 2.5, 2.5, 2.5. Now 10. Would it come one? Would it 55? So it is here. And so now when you're indefinite, we are so working 1 year. Oh, when you're 60, 55, yeah, 56. Oh, and so now when you're no, is my math right? Yes. 25 plus 20, 45 plus 10, 55 plus what? 56. And so now when you're indefinite.
Because a UK.
Of course. This is the country.
Obiane na dream o ba me say the emfa. Nti obiane na dream. Obiane do. Na if you na better 20, wow kan ye nti me di be 30 years aka wansa. Say me 25 years, I me di 30. Hey. Anyway, the angel na Lawyer Wisdom Akao wise man solicitors. Social screen so ama mobisa the numbers, office numbers na o no, and the mobile number da ho no. Obetimi contact you omo. Office location or London, Dawson Junction, McDonald's or McDonald's in China. Obeka just say the print house and so on print it. Hey, Lawyer Wisdom Akao, lawyer, my office location here and sign out. Me that say ne the abegu nyame aduma next week Friday. Every Fridays be a from 5:30 GMT. Until see ano mo UK for more UK the muli di and 1 hour. Until 5:30 no me will local base me will Ghana. 5:30 no na say mo 6:30. Until 5:30 to 7. Until see ano say about 8 or more until 1 hour na muli di. Every Fridays be a say lawyer. Office location and sign out me that's say ne only update we bre la sound article me say me tonka
20 years Nisa. And also do minimum bills are already 32. Azana, you're sorting it out.
Lawyer. I don't feel like we are sim. Two number now we have now struggle because of Kata. But Tinemusa, many mammy cry interview UK. Hey, what Tinembe, look, what Tinembe 20 something years. I feel I was even in cat also about Ghana. About 22 years was 20. Hey, why?
The book nini wa uni ase se upia won't remember bio. Wow. And sometimes they put them we try 5 years, we try 10 years, say, oh, me go back. First of all, you may be anywhere or go back to it. So, that is normally the assessment. You may be anywhere, may go back to. 2. Ebia nyama kakra na all yans and all bano. Wa disposal of nina. As I say, be all toy and all bano. Waton. a human knew readily or qua or wakoye. Business beyond so new when it capital beyond so the started business beyond say. Into a year assessment this did you not so look me did name saka crack at least and ye cry bet me a credit. Na me the beer money mofran so no the school fees. We share not 2 years above account, not 5 years above account, not 7 years above. And yes, sometimes and yes I share that say but number 20 years old. But circumstances no na yeah a pushing here echo sa trend so yeah and
so
circumstances
obetena Ghana obewu betena the chrome obewu
yes
o pressure ye na nanom ye papa mo nkrase no mote no mo ye fuo no mo de ahwa ye de ma ye ho pressure dodo se broni chrome de oye yen omo ma ye pressure dodo na o wie so a san kwako o ade bi package bi kwako renew omo use so madwin na ma ji uske bi obetia 3,000 pound 5,000 pound sa omo de bi do mo kro because obetena o na o so gba okro ma enye yi emfa ma obi ade ne de
when the abusiansa say bia kra na wakoye small farming was so
and I say obi ane the case me dey say me kama me ho obi ane ne de sa atiti we mu me ntina 20 years na bia wo mba kra wo Ghana na say we kra hu omo ye 20 years over 20 years so anya na hu omo phone so na mo kasa ho hello hey chale that's not how can 20 years is 30 years now we so na they say oh the lawyer tinyama meet me kan wa to the angel is a lawyer office location na minja
DJ Nyame and until na the education every and Crawford say nipa mienu aba mumi no nyina mudi BA and a bay mu nyina mabedu ene mabedu terminal 5 mienu obiti seat B23 obinsu seat B20 23A 23B yeng na ya bedu DJ wo so betwen 20 years media me cement me 20 years yeng na e ba ye yeng na e pay terminal 5 yeng na e ba krum one day who they also go 20 years me city 20 years element me 20 media me peba na ma wo me ba ne ma me a British and or indefinite me ba ne British me a serious person I'm involved in my child's life me no serious contact me family me see me ba from me channel come on going and coming me no pictures evidences say or me ba DJ was a who 20 years no. Maybe banner might one or the British or British citizen within 1 to 2 years. Me manya madio. DJ ni American here. Yes. And the was a who 20 no. Me 1 year, 9 months pregnancy. After that child is born, my child is a British citizen. Genuine relationship. DJ. Within a year to 2, I'm sorted. Me person me try 10 years and see me first 1.5 years now on the 10-year road. No switch it to 5 years. So in 6 years time or so, Miami indefinite. In another 1 year, Miami British citizenship. So maybe 7 years or 8 years, Miami British citizen. Whilst I did who does try for 12 more years.
The okay in your so sika no obetua ansa na wakonya citizenship no.
Your contact address no. Yeah.
Lawyer, me person go vote here for educational purpose. Sir, me know yes I break down that omo new sika omo jenia there. It is a short course now. Kind it's just short way now because we benya book no. Ahina obebo ka on ansa na do dey my is break down na minja ho. Ahina obetuatua ansa na sika obetua ma home office for na ansa na onya sa book no. O dey boss ask can trouble.
Ansa na mama me contact details. Maminya quick calculation be my wife.
Me calculation ma me be say man for say short course we now can discount enam. It is a short na urubenya ansa na urubenya British book no. Sika hin na obe boabo na obe send am home office.
Okay, let's assume say nipan ebeko 5 year old. So the first one home office fee is 1,321 plus IHS and now you can say £2,587 and 50p. What did you mean in the bomb one? 3,900 and 3,000 £908.50. That's the first application.
Mm.
Yeah, due to 10-year route now over 5-year route over the same amount. So that is times 2 for the first 2.5 on the 5-year route. Another 2.5 view, and about this amount times 3. Now I get £11,725.50. No akwaji indefinite near £3,029. Udi can one. Oh, mami. Okay, so we have £11,725.50 plus £3,029. Udi can one. 14,754 pounds. Now I got the British citizenship now, which is around 1,007 plus. So let's say 1,008. And all in all, you are around 16,554 pounds. That is for the short route.
And before me menya British book no, about citizens no. A citizen no, me tia me boka £16,000. Na the whole hey, lawyer, I don't want to talk matter. Who the engine has say it who the jai because I go talk something. Some people say go ball. It's who the engine. Lawyer office location. I mean,
yeah, more 2.5 years no. What me ejuma? What me well, at least what me 2 quiet. If for nothing at all, what me I could GH, I could show Busian for. Yes. So DJ, let's it is a long time, it's a lot of money, but sometimes the pressure it takes off you cannot be quantified in monetary terms. The pressure every year too, it cannot be quantified. So sometimes the sacrifice is worth it. It's worth the sacrifice sometimes. But I know there's for another day. Let's talk. Wise Smart Solicitors. Your suit 18 to 22 Ashwin Street. Wise Smart Solicitors 18 to 22 Ashwin Street. Your Dawson Junction behind the McDonald's. Door number 18 to 22 Ashwin Street, suite 8 to 9, the Print House. Postcode near E83DL. E83DL. Telephone numbers is 0208 0165 384. 0208 0165 384. Mobile number near 079 31 411 042. 079 31 411 042. You will close to the Dawson Market, close beside the behind the McDonald's, and 18 to 22 Ashwin Street, 8 to 9 the Print House. Telephone numbers no na ewo a screen no so no. Uba ebesho. DJ, let me say this. Some of the questions now say bisa me and go into too much explanation. And because I need to ask some more questions, get some more information, etc., and we don't have the resource or the time to do all of that. Set who will follow up, please call the number, book appointment, come, let's sit down, and I'm sure you able to me dive into other areas and of course give directions. I'm happy to be of assistance. Thank you again, once again. Every Friday I want a time nami ava program yeji akwe Facebook akwe TikTok play tokata DJ akpe maone job awe aka da Friday now umana be umamba here umanga education maone job onlo nani uma pay fair mau enine ehime ni ejomo onlo
lawyer mochum onu kema oyebua next week Friday o makpe yo 5:30 to 7. Onu Wise Smart Solicitors mochum o matumunyu later. Lawyer Wisdom Akaoda Mutienu straight from the UK on every Friday be information or the bremo or a good lawyer. When starting in the year program, it's our first time in check. Yes, me starting in the year. But anyway, minjana. Me don't want to say some share SVTV Africa videos were your page, so amount for experiences Ghana, among businesses for Ghana business link. Me the breeding komo. Tibia follow and now tibia beboa. Enti kake. Fabibi film. Me the be am say Fabibi na tu anamo. Start with whatever. Your mind be bia wa mindset. Just call boy. Cause me in Kratanti in UK. I mean say 16,000 short. Say be jumecha. For doku. Anyway. Madam Answer share SVTV Africa, Madam Production Team. I say, subscribe to your channel for more. Share Mukruma, I say tour, no majesty to tour. So, tour.
Hi there, my name is Calipos, the only boss with one S. Happy new month to all of you. Welcome to a month of new possibilities. Why life has been made so easy? It's because of TapTapSend. People, TapTapSend is here to make your life easy if you want to transfer money to Ghana, if you want to transfer from USA, if you want to transfer from UK, Europe, Canada, a lot of places all to Ghana. And guess what? When it comes to Ghana, there's no e-levy charge. So, what are you waiting for? Download TapTapSend on Google Play Store and App Store and be ready for exciting offers coming your way each time, every time on TapTapSend.
TapTapSend. Send more, spend less.